for Protecting Assets from Creditors, which is brought to you by Law Practice CLE. The course materials can be downloaded on the left side of the screen. If you have trouble accessing the course items, please contact admin@lawpracticecle.com for assistance. If you would like to submit a question to the presenter during a live program, please do so via the chat box. If you are watching a recorded program, please submit the follow-up question to the presenter directly via his or her provided email, or alternatively, email admin@lawpracticecle.com. Please include the date of the presentation, the presenter, and the title along with your question. Now a few record-keeping and course credit items. In order to receive CLE course credit, you will need to be logged in for the entire program. At the end of the course, we will provide you with an evaluation form and acknowledgement of attendance. Formal attendance will post the following business day, and the official certificate of attendance will be sent out via email once final approval has been received from the state bars if it was not approved in advance. If your particular state bar requires the sponsor to report attendance, Law Practice CLE will do so within 30 days of the course attendance date. Thank you again for selecting Law Practice CLE. And my name is Eric Boughman. I will be presenting to you today on rules for protecting assets for creditors. I am a partner with the law firm of Forster Boughman in Maitland, Florida, which is in Central Florida. We practice throughout the state and throughout the country. My practice involves asset protection. I also do a significant amount of technology and healthcare law work. And my firm is involved in all areas of business transactions, corporate tax, and litigation related to the same items. Again, if you have any questions, I welcome those via email or phone, and my contact information will be at the end of the slides today. So I'm not going to try and give you a comprehensive course on asset protection in an hour. Instead, what I'm going to do is I'm going to cover some rules that will, once we get through the rules, give you hopefully a very good understanding for different things to be aware of when engaging in asset protection. And here's an overview of essentially a list of the rules that I'm going to cover. And I'll talk about these each individually for a few minutes over the next hour. You'll see the first one on the list here is don't do asset protection. And what do I mean by that? It sounds counterintuitive to anybody watching or presenting a seminar on how to do asset protection. And really, it's about misconceptions. Oftentimes, as a lawyer who does a significant amount of asset protection work, the phone will ring or an email will come in. Oftentimes, it involves a phone call or a meeting with a client, and the client says, this happened, I need, something bad happened, an accident or some other liability event. I need someone to help me with asset protection. And at that point, really, it's just too late. So the idea is we want to do away with some of the misconceptions. Asset protection is not about hiding assets. It's not about shirking out on obligations. It's really about using existing laws, statutes, exemptions, titling, and other protective mechanisms to essentially take some of your chips off the table and not make them available to creditors in the event something later happens after you engage in planning. From a policy perspective, there are debates, and I've done a lot of seminars with individuals who get almost offended at the idea of using the law almost like it's a loophole, like you're using the law to prevent your assets from being attached by creditors, to avoid exposure. But the counter argument to that, and what I often try to present, is that everybody has the same choices when they have any assets that they want to protect. You can gift away those assets. If you're not subject to any claims, you can give stuff to your kids, you can give stuff to friends and other relatives and family members. You can go to Las Vegas and blow it all at the casinos. You can take extravagant vacations. Anybody that ever saw the movie, I think it was called Brewster's Millions years ago, about Richard Pryor trying to unload a bunch of cash in order to actually get a bigger payday at the end, knows that there's all sorts of creative ways that you can spend and deplete assets without actually being sued or having them taken by creditors. Alternatively, you have a right to protect your assets instead of giving them away. Why shouldn't an individual be entitled to, rather than giving their child $1 million, put $1 million worth of assets into a trust so that it can be spent responsibly for their child's benefit, maybe upon reaching certain benchmarks? Why shouldn't somebody be able to save for a rainy day? If you think about think about two people who both have today $1 million. The first person blows that money over the next year on gadgets and toys and cars and trips and so forth, and the second person saves it and invests it, and now 1 year from now, each of those folks is involved. It could be something as innocuous as they lend their car to somebody and that person has a car accident, and now there's exposure beyond the limits of the car insurance that will expose the assets of the owner of the vehicle. I've seen that situation several times. Well, in one circumstance, the person who blew everything they had really has no exposure. It's probably going to walk away. It's not going to be of much interest to any plaintiff's attorney, and that person's going to walk away scot-free. In the second instance, the person who was the saver and would appear to have been the more responsible of the two, that person now is going to suffer potential exposure and liability and loss of assets simply because they saved their assets for a rainy day. And now here comes some plaintiff's lawyer or some claimant who sees that and sees an opportunity to take some of what the other person has. So there's several policy reasons to support asset protection. Obviously, unbridled tort exposure, runaway jury verdicts have been newsworthy over the past several years, unmanageable insurance costs, and other concerns. And there's policy reasons even when you look at bankruptcy that allows people to get a fresh start, statutory exemptions that keeps out of the hands of creditors things such as your Florida homestead if you're in Florida, or some other states that protect the homestead, retirement accounts, education accounts, certain types of insurance and so forth, and annuities. There are statutory mechanisms that are used to protect assets, and these all go back to a general policy concern. And what we're doing with asset protection is we're really trying to take advantage of these different laws and rules and exemptions and put that together into a package to maximize somebody's protection from unknown future creditors. And that's what I think is most important, is that it's not dodging a creditor that exists now. It's getting away from the future unknown. And so, as the slide here says, asset protection offers individuals the right to govern their own moral compass with regard to finances. Someone may say, well, what if I do cause an accident and I hurt somebody and all my assets are wrapped up somewhere else? It doesn't seem right that I shouldn't have to pay for that damage or that liability. And in fact, asset protection gives you the right to, with your own moral compass, pay for those things if you think it's right, but at least you're not exposed legally, so that you at least give yourself a choice. And as I've alluded to initially, and I'll continue to talk about, intent and timing are of utmost importance in asset protection. So in this first rule of don't do asset protection, what we're really talking about, again, is don't consider asset protection as some way to avoid existing liabilities and existing claims. If you have a claim, that claim is entitled to be paid, but if you don't have anything on the table, you have an opportunity to put something aside. It doesn't always, sometimes the intent of the parties when engaging in some type of protective mechanisms is important, and these two cases help really demonstrate that statement. In Kilker v. Stillman, briefly, this was a case that came out of California. It's an unreported decision, and people that look at this will say, well, it's unreported, so it doesn't mean anything. But what I would say in response is that it certainly meant something to the parties, and it certainly is an example of what can go wrong when you go to court. In that case, the defendant was an engineer who had done site planning work, and he did it at a time early, I believe it was in the early 2000s, and the plaintiffs ended up having a problem with the pool, and they sued the engineer in between the time that the plaintiffs knew that there was a problem, which was several years after the work was done, and when they filed suit, the defendant engineer put assets into some Nevada trusts and essentially engaged in some asset protection to take assets out of the exposure to creditors. He was sued by the plaintiffs, and in that lawsuit, he initially agreed to, and he entered into a settlement agreement and agreed to pay, but he immediately failed to pay under the settlement agreement. So courts don't really like that. So now he doesn't look good in front of the court. He's already reneged on a settlement agreement, and he ends up in court, and he's testifying in court, and he testifies to the extent that, well, I don't have any assets in my own name. I've engaged in asset protection, and so somewhat flippantly from what I gather from the testimony, he basically says to the court and to the plaintiffs, I don't have anything that you can get, so I'm untouchable. Well, the court didn't like that, and the court ended up sort of taking a fraudulent transfer rule, which pertains, in my view, to existing creditors, and twisting that rule a bit. And what the court says is that any action that you take to protect assets from creditors is done with an intent such that the creditors don't have any ability to collect. It's done with an intent to avoid creditors. And when you do that, you commit a fraudulent transfer. And so the court said that any transfers that were done as fraudulent transfers could be reversed, the assets are exposed, and the plaintiff could collect. Well, what you gather from that case is that any mechanism of asset protection, any action that you take to protect assets could potentially be deemed fraudulent. That seems a little bit extreme, it seems a little bit excessive, but that's, if you read the case, that's the rule, what comes out of that case. And in my view, I think a lot of that had to do with the fact of the behavior of the defendant, how flippant he was about engaging in asset protection, the fact that he left no assets exposed. He said he had no more than $500 to his name. The fact that he reneged on the settlement agreement. There's a lot of bad facts, and it's really one of these cases where bad facts ended up with a bad result for the defendant. Contrast that with BB&T v. Hamilton Greens, and that's a case here in Florida where one defendant was sued as a guarantor on a loan, and he was sued by BB&T Bank, and in the midst of the lawsuit, he transferred approximately $1.6 million into an offshore trust to benefit his children. And when he was called into court on the fraudulent transfer claim, which was to be expected, his testimony was that, and I love this part, if you actually pull up that case, you'll see where he testifies essentially that he didn't intend to avoid paying any creditors, he just wanted to set aside money for other purposes for a later date. In my view, that's sort of a zero-sum calculation. Either the money's going to go to creditors or it's going to go for something else. But the court seemed persuaded by that. What I think the court was more persuaded by was the debtor's attitude and his explanations surrounding the circumstances of the transfer. There, that guarantor testified, one, that the real estate that secured the loan under which he was sued was at one point valued much higher than what the loan liability was. And there were several other folks involved in the loan and the development and co-guarantors who had agreed to pay any liability in the event that the loan was in default. And so he had other reasons to explain to the court and to believe that he would never be found liable for the transfers, that he would never be found liable under the loan, and thus he wasn't worried about the creditor when he made the transfer into the trust. And so there was no fraudulent transfer concern. And the court actually bought his testimony and found that there was no fraudulent transfer. So these two cases show in Kilker where the timing is such that there really wasn't a fraudulent transfer issue. The transfers occurred long before there was ever a claim on the horizon. Whereas in BB&T v. Hamilton Greens, those transfers occurred right in the midst of a lawsuit, and yet the results are exactly opposite of what we would expect. So I've spent a little bit more time than I intended talking about those cases, but I think it's important to understand big picture-wise that the intent and timing of transfers is of utmost importance when you're looking at asset protection. So the second rule we'll talk about is that you can transfer assets freely, but then in parentheses here, not really. And what that means is that up until the time of judgment, there's in particular a Supreme Court case that says to the effect that you can transfer assets without concern for any creditors up until a judgment's entered. And that would suggest that you can transfer assets when you've been threatened with a lawsuit or when you've been sued, and not worry about liability. The creditor can't typically run out, or a plaintiff can't typically run out and freeze your assets in advance before getting a judgment, absent some extraordinary circumstances like having security or posting a bond or so forth. But there are exceptions to that. And so while you can transfer assets freely, and you should do so well in advance of any negative events happening to protect those assets where it's possible and feasible, those rights to transfer are subject to fraudulent transfer claims and other legal claims that we'll touch upon here in the seminar, such as alter ego and sham claims, and other entities that might be disregarded for other reasons, such as violating public policy and so forth. All right, and on the topic of fraudulent transfer, so when you have a fraudulent transfer, and we're going to talk about this on a later slide a little bit more in detail, but a fraudulent transfer essentially is transferring assets out of the grasp of creditors after a claim has arisen. It's taking action once the clouds are on the horizon. And it's when you take action with an intent to avoid a creditor, and that intent can be shown constructively or through actual intent of a potential debtor. And we have certain defenses that we want to be aware of with respect to a fraudulent transfer. And among those defenses, we have what I like to call legitimate supervening purpose. And that's what we had in the BB&T case. We had somebody who testified that his motive and intent for transferring assets wasn't to avoid the creditor, but instead it was for other reasons that were more bona fide, so to speak. Other defenses to fraudulent transfers are statute of limitations. There are valuation concerns, and we're going to touch upon those in a few slides later. There are several exemptions, both under state and federal law, such as the homestead exemption in Florida that we have that prevents creditors from being able to take your personal homestead, provided that it qualifies as a homestead and provided that you did not take the funds from a fraud or crime or those used to purchase or improve the homestead to actually protect those within the homestead. But otherwise, you have very broad statutory protections, again, under federal law and under state law. Retirement insurance, I listed some other examples here. Education funds, oftentimes those in a 529 or education account will be exempt. The way things are titled, that will create some exemptions as well. If you're married and you're in a state that recognizes tenants by entirety's interests, it's oftentimes to your benefit to title things as tenants by entireties. Husband and wife, by titling something as a husband and wife tenants by entirety's interest, you've now made that made that property marital property. And in order for a creditor to attach that property, they have to have claims against the entire marital entity, both husband and wife. So for somebody like me, for instance, an attorney who is in a profession at risk of being sued for professional liability, or a physician or some other person who provides professional services, if you have a spouse and your spouse is not involved in the same business, it may be a good idea to hold certain assets such as financial accounts and other investments as tenants by entireties with your spouse, because claims against the individual spouse will not touch those marital assets unless you have a judgment against both spouses. So tenants by entireties is another specific titling exemption. And again, there's public policy concerns to support that. So the next rule for asset protection, and again, it's along a similar theme: buy your umbrella before it rains, or avoid late stage transfers. And there's a case here that I'm going to talk about that will provide an example of the problems that you can run into when you do try to transfer assets after a claim has arisen or after a judgment's been entered. In this Travelers case, this was a case here in Central Florida. It was Travelers Casualty and Surety Company of America v. Design Build Engineers. And in that case, the defendants were sued by Travelers, and they had been performing a construction contract in South Florida. Something went wrong with the contract, and the the contract that was bonded off, essentially the bond came due and had to be paid by Travelers, and Travelers turned and looked to the defendants to reimburse them for the bond claim. They sued the defendants in the Middle District Court in Central Florida, and under the language of the agreement between Travelers and Design Build, Travelers had a right to require Design Build to post collateral to cover any potential losses and obligations. Design Build did not post collateral. Instead, Design Build and its principals, they actually did something that I totally recommend against typically when folks are faced with some type of potential liability event, and that's they started moving assets right away. And so when a client comes in and I'm talking to a client, and they say, okay, I've had this that happened, what should we do? The first instinct in anything happening bad is to start retitling things and moving property around, moving accounts, opening and closing, etc. That is bad news, and it can set you up for trouble. In this case, it provides an example. The defendants here moved the money in and out of a couple different accounts, and they ended up having move their assets, and then ended up putting their assets in two places that are typically considered safe. One is in a Florida homestead, so they paid off their mortgage. They had an expensive home. They paid off the home with part of the funds that would be exposed to Travelers. And then they took money and they put it in a bank account in Delaware. And some people are aware of this, especially if you're in Delaware. If you're outside of Delaware, you may not be aware, but Delaware has a unique law that applies to Delaware, the financial institutions in Delaware, that essentially states that Delaware banks are not subject to attachment and garnishment orders. So in other words, if you're an individual, you keep money in a bank that's in Delaware, provided it's chartered and it's only in Delaware, and you keep money there, a potential plaintiff or claimant will not be able to garnish those funds or reach those funds through any type of legal process in Delaware. They'll have to come up with some other mechanism to reach the funds. And I've seen this where people have had success in keeping assets in a Delaware bank account to keep them away from creditors. There's some mechanisms the creditors can use to try and compel people to repatriate those funds back to a jurisdiction where they can be attached, but that's a totally separate fight. Here, Design Build put money other than what they put in their homestead into the Delaware bank account. And then they looked like they were in a pretty good position, except the Travelers moved for an injunction in court and asked the court to enter an order of injunction compelling Design Build to post the bond in cash with the court that Travelers was entitled to under the contract. Now, to me, this looks like purely a claim for money. And they're not asking for anything unique. They're not asking for any other type of performance. They're essentially asking for money. They're asking for a bond to be posted and for Design Build to take the money and put it in the bank account. I suppose that's an action, but again, it comes down to what's ultimately the remedy Travelers is seeking here. They're seeking money, and anybody that's ever dealt with injunctions or had experience with injunction cases in litigation or in any type of dispute or drafting any type of language that would provide for injunction as a remedy knows that injunctions typically are used for non-monetary remedies, for equitable remedies. So it would have seemed that the claim by Travelers in this case should fail. But the judge, and I know this because I actually know people who were involved in this case and have talked to people about it, the judge was so turned off by the fact that these assets had moved into separate different accounts and been shifted around. I think that influenced the judge's decision to enter an injunction order and require Design Build to post a bond. And I don't remember what the number was. It was over $1 million. And sure, I still think the decision was probably incorrect. The problem, if you're Design Build or if you're Design Build's counsel, is how do you advise a client under these circumstances? They've been ordered to post bond with the court in the amount of over $1 million in the next 10 days. In order to do that, they'll have to liquidate funds that they put into their homestead, repatriate funds in a Delaware bank account, and come up with any other money. And now those funds are exposed because they're in court. Sure, they could say, well, that's legally incorrect and we're going to appeal. But during the time of appeal, they run the risk, if they don't post that bond, of being in contempt of court. So then they could end up in jail. Well, you could maybe bond off the requirement and and stay out of jail in order to appeal that decision to the 11th Circuit. But again, that's going to require you putting cash in court. So you're really in a catch-22 situation, and that was created, in my view, really because design build waited too long. They waited until it was dark, cloudy, and they were in the midst of a thunderstorm to decide to seek an umbrella, and that was a mistake. So I touched on the earlier slide about some defenses to a fraudulent transfer, and I told you that a fraudulent transfer occurs when when a defendant or somebody subject to a claim or judgment moves assets with the intent to avoid a creditor. This goes into a little bit more detail. On this slide, you have constructive fraudulent transfers, and that's circumstances surrounding the fraudulent transfer. And usually where you see this is a transfer of an asset to somebody for less than reasonably equivalent value, i.e. I transfer my $20,000 car to my brother for $100. That's a transfer of less than reasonably equivalent value. And I do that, and it results in me being either insolvent or in some way unable to pay debts as they come due. That would be, insolvency is defined two ways generally under most statutes. It's either balance sheet insolvency or unable to pay debts in a normal course, or it leaves me undercapitalized for certain business or other activities in an unreasonable way. So constructive fraudulent transfer is essentially an objective view. The court takes a look at what was involved with the transfer, what went out versus what came in, the transfer itself, and whether there was reasonably equivalent value, and then the result upon the debtor that occurred due to that transfer. Did it leave the debtor insolvent or unable to operate properly? And typically courts will take into account the actual claim that's outstanding when making a determination of those financial factors. The other way a claimant can prove a fraudulent transfer is through actual intent to defraud, and that's through what are called badges of fraud. You can look at almost every state will have a list of what are generally called badges of fraud. These are factors that a court will look at to determine that a debtor transferred assets with intent to avoid a creditor. It's things such as transfers to insiders, transfers for less than reasonably equivalent value, transfers with late timing, transfers that are hidden, they're made in secret. Now, back when I say insiders, I mean family members or somebody else related to the debtor. The circumstances of the transfer, there's oftentimes a list that's a non-exclusive list. There may be other factors a court will look at that are not in a statutory list, and you don't have to meet all of those factors, but it sort of gives you an idea of the things a court will look at when determining whether a fraudulent transfer has occurred. And so when we talk about things like legitimate supervening purpose that I mentioned earlier, that is factors that you can raise that will minimize the effect of or reduce or offset those badges of fraud. So what are the bona fides of the transaction? So you prove fraudulent transfer through either constructive fraud or actual intent to defraud. Another mechanism that courts use to get to assets is through alter ego. And alter ego is where a company, usually you see it with an LLC, but you may see it with a trust or some other business entity, and that entity or separate existence is totally owned and influenced and operated by the members who've transferred assets into it, and such that the separateness, the legal separateness of the two ceases to exist. It's really one is the same as the other. One is the alter ego of the other. And when you have an alter ego situation, particularly where that entity or other legal existence is used for fraudulent purposes or used for wrongful purposes or used to help perpetrate a fraud, courts in some jurisdictions may find that it's the alter ego of the debtor and unwind transfers or disregard transfers that are made into that entity. There's a case here that I put in your materials. It's Sky Cable v. DirecTV. This is a recent case in the Fourth Circuit interpreting Delaware law. I'd be interested to see how Delaware responds to this, where in that case the debtors there had single-member LLCs that were used to help perpetrate a multi-million-dollar fraud, and there was no business purpose to the LLCs other than to hold specific assets. And there the court found, and this was a quote of the court, overwhelming evidence that the entities were merely alter egos of the owners and not separate business entities. What makes that case particularly unique is that in Delaware, the LLC is protected against foreclosure or seizure by creditors, including whether it's a multi-member LLC or a single-member LLC. Some jurisdictions don't protect the single-member LLC, such as Florida, so it would allow foreclosure. But in Delaware, Delaware has language in its statute that protects the LLC from foreclosure. So in my view, the court gets around the foreclosure issue in this Sky Cable case and gets around that single member with multi-member distinction. Doesn't have to deal with it at all. It doesn't have to deal with the restrictions on foreclosure by simply making a finding that the entities were the alter egos of the debtor, were used to help perpetrate a fraud, and therefore exposes the assets of that LLC to the creditors. There are other cases. If you find that case, you'll find other cases. It's sort of a jurisdiction by jurisdiction approach. So whatever state you're in, you have to look at the jurisdiction and see if alter ego is recognized. Some states may recognize it for corporations and LLCs, but not trusts, or vice versa. I know in Florida here, there was an alter ego attack on a trust a few years ago. It was in Ohio, but interpreting Florida law, where the Ohio court said, we don't think Florida would have an alter ego for trusts, but I'm not aware of any cases in Florida that have opined on that. So you just need to check in your particular jurisdiction. Finally, another way that creditors will unwind transfers is simply through choice of law or public policy arguments. One example is this Wells Fargo case that I've cited here. In that case, Wells Fargo sued Sabrina Barber, who had defaulted on a loan. Ms. Barber made, in my view, the same mistake that the folks made in the Travelers case. Is that is she liquidated her homestead, which one I think was a bad idea because the homestead was protected. She took funds from that homestead and she moved them into different bank accounts, and she ultimately moved them into an account that was owned by a Nevis LLC. And that's important because a Nevis LLC, it's an offshore LLC formed under Nevis law, and Nevis has strong protections for the single member LLC and for every LLC, and it also has strong protections against fraudulent transfer claims. Well, that case ended up in the Middle District Court in Florida, and Ms. Barber had testified that her assets were in this LLC. It was a Nevis LLC, and the court found that since the LLC interest, particularly because it was not certificated in this case, there were no LLC certificates, that the interest was an intangible interest that attached to Ms. Barber because Ms. Barber was in Florida, and in fact in court, that the court had jurisdiction not only over the debtor, but also over the LLC interest of the debtor, and ordered that the LLC interest was subject to Florida law, which allowed foreclosure of the single member LLC, and therefore allowed Wells Fargo to seize that interest. Once they became the owner, the recognized owner of the LLC, Wells Fargo now essentially controlled the LLC and could access the bank account. That was just simply a choice of law argument. We see that a lot. So it's important to understand what jurisdiction and what law you're dealing with when you're doing asset protection planning. All right, the fourth rule or fourth object we'll touch upon is don't be greedy. And what this really means is when you're doing asset protection planning, you don't want to take everything and stick it all. You don't want to take all your assets and try and put it in an offshore trust. You don't want to take all your assets and stick them away so that you have nothing to live on. You don't want to be the defendant from the Kilker case who says, well, I only have $500 in my name. Courts aren't going to like that. It's not going to be realistic, and it's potentially going to, overreaching is potentially going to create exposure. But there's also another issue here. It's just valuation concerns generally. And I've written on this, and I've done full 1-hour seminars just talking about these concepts, but I just want to give you a brief overview. We talked earlier about reasonably equivalent value. When you're talking about reasonably equivalent value, it doesn't necessarily mean fair market value. It doesn't mean total equal value. Consider an example to illustrate this. If I need to come up with $10,000 by tomorrow, and I have a fancy watch that has been handed down to me as a gift, and that watch has a appraised value of $15,000, I might not be able to sell that watch in the next 24 hours for $15,000. The most maybe I can get for it on Craigslist, Facebook, wherever else I try and sell this, or some secondhand shop, might be $5,000. And so $5,000 might be the reasonably equivalent value for that watch. So that's one issue to consider when you're looking at particularly fraudulent transfer analysis. Reasonably equivalent value doesn't necessarily mean full value. It means reasonably equivalent. And you see that word over and over again in fraudulent transfer cases, reasonableness and reasonably equivalent. Also, when you're doing an analysis and you're looking at a potential defendant or debtor in a situation looking at a claim, we see this a lot with, let's say, a physician who thinks maybe a malpractice claim could be filed. I had in one circumstance a client who a demand had been sent, but the requirements had not been all satisfied to file a malpractice case. So no malpractice lawsuit had been filed, but a demand had been sent, and the client truly believed, and there seemed to be a lot of evidence to support the fact that the client really was going to have no liability and had insurance coverage and so forth. But the client also was going through some other issues, in particular some life-changing events, and had intended to restructure assets and engage in some asset protection. So when that client walks in the door, do we tell that client, well, no, you have a potential claim, so there's nothing we can do for you? I think the better approach is to take a specific look at every client and look at what their circumstances are, and take a look at what the claims are. Here we had a claim that, one, might have no merit, two, it was certainly disputed, three, may never be filed, four, may be covered by insurance, five, may go to court, and even if it goes to court, it never results in a claim, or the value of the claim is substantially reduced in settlement, or the claim gets defeated in some court action. You've got all types of contingencies and disputes attached to that claim. So the idea is to come up with a value or come up with circumstances that you can, in some cases, plan around that claim. You need to be very careful that I'm not advocating here that you use valuation to commit a fraudulent transfer by coming up with an unreasonable analysis. Contrary to that, I'm stating that you can take valuation of particular contingent claims, disputed claims, and use that as a baseline to determine whether or not your client has a cushion, so to speak, to take certain assets and still take those off the table so they're not available to creditors. We always make clear to clients when they come in that you're not going to be able to avoid any potential current claims. So if you know you owe somebody $1 million and you're trying to engage in some protective planning, and you've got $5 million, you need to leave $1 million on the table. That has to be set aside to cover that potential liability. But oftentimes liabilities aren't real clear. There's all types of issues that attach to those, and that's what we're getting at with the valuation issues. I put an example here in the slide. This is from a bankruptcy case. A lot of these concepts come out of bankruptcy. That's where we see a lot of these concepts first develop, because bankruptcy is always dealing with assets and claims of creditors and debtors, so they tend to see these issues first. But here is an example of where a probability discount was applied, and the court uses this example where Company A, valued at $1.7 million, guarantees a $28 million loan to Company B, and then suppose that when the obligations are assumed, there's a 1% chance that Company A would be called upon to satisfy a claim, yield off assets to Company B. What's the value of that particular claim? And the court says it's not 1% of 28 million, it's 1% of 1.7 million. And so that can affect how you ultimately engage in planning. But I also want you to be aware of not being too aggressive, and understand that hindsight becomes an issue here. Some courts will look at assumptions that are made when you're going through valuation situations and scenarios, and we'll look at those assumptions and ask the question, is that assumption reasonable? Or was it, well, first they may ask, was the assumption reasonable at the time it was made under the circumstances that were known at the time? That's a more reasonable approach in most circumstances, but other courts might look at it and say, when we look at what you did now, today, were the assumptions that you made reasonable? And that's the difference in how hindsight can play into a court's analysis on whether or not a fraudulent transfer occurred when you move the assets based on these different valuation issues. So again, I just touch upon valuation. I just want you to be aware of how contingent claims and disputed claims, as well as assets. You may have a client who has an asset, has a claim against somebody, but there's only a 30% chance of success and the dollar value is unsure. You need to know how to figure that out when you're providing an analysis for somebody to determine whether or not asset protection is appropriate and to what extent you can engage in such protection. All right, next rule, choose the terrain wisely. This goes back to jurisdiction and choice of law. You need to understand, one, where is your client, and where is your client likely to be sued or subject to being sued? Is it a business or is it an individual? Some states are more protective of debtors and protective of asset protection mechanisms. Some states are less protective. California has had some cases that really, including that Kilker case, that would make California a place that I would not want to practice and go out on a limb trying to extend the law too much to protect clients who really weren't acting with complete bona fides. On the other hand, Nevada and Delaware in some circumstances, Wyoming in some circumstances, there are some other places that are known to be more protective. Alaska, which is the first place to have self-settled trusts, a little bit more protective. So you need to understand, where are you when you're doing your planning? What jurisdictions do you have to operate with? Understand your own state's law, and then also the choice of law issue. And this goes back to what I mentioned in the Barber case. There's another case that we'll talk about with choice of law, and essentially the question is, what law is going to apply? Don't assume just because you are in if you're in Florida and you create a Delaware LLC, that Delaware law is going to apply to claims against the membership interest of a Delaware LLC. Understand what the cases say, and the cases are all over the board. So where you are when you plan, what state's law, there are reasons sometimes why you might use, if you have the right circumstances, why you might use a Delaware LLC. Delaware is real popular. Nevada is real popular. If you're trying to create a trust for somebody and you're creating a self-settled trust, Florida is a place that does not recognize self-settled trusts. I know people try to create them here in Florida and say that you can do it. I've heard of attorneys doing it. It will not stand up if it's challenged in court. It's completely worthless from an asset protection standpoint. But other states do allow self-settled trusts, such as, again, Alaska, West Virginia, I believe, has recently adopted a self-settled trust statute, Delaware, Nevada. So understand your jurisdiction and understand what law is going to apply. I talked about the Wells Fargo case earlier. Here's some more notes about Wells Fargo. And then I give you another case here in the slides, which is this JP Morgan Chase v. McClure. And this case went contrary to Wells Fargo. In that case, the court, there was a bunch of rulings that were made in the case, but essentially the court rejected the Wells Fargo approach and said that when an LLC is formed in a particular jurisdiction, then that jurisdiction's law will apply to the LLC. That was the argument that Ms. Barber was trying to make in Wells Fargo. And if Nevis law had applied instead of Florida law to that interest, then she would have been able to hold on to the LLC interest subject to a charging order. Another example is this In re Huber case. This is a bankruptcy case out of Washington where a bankruptcy resident set up a self-settled trust, but most of the assets, one of the trustees, all of the beneficiaries, the settlor himself were all in Washington. And when push came to shove and the trustee challenged the transfers in bankruptcy court, the bankruptcy court based on where all the assets were, and further based on public policy reasons, specifically that being that Washington did not have a self-settled trust statute, and Washington public policy was against such mechanisms. The court essentially ruled that the trust would be disregarded for any protective purposes, and the assets in the trust were exposed to the creditors and the trustee in that bankruptcy case. So again, as I put in the deep red here, jurisdiction and choice of law can have a profound impact on whether your domestic asset protection trust will survive, on whether your single member LLC will be subject to foreclosure, and many other issues when you're engaging in asset protection, and you need to be aware of those. All right, Rule 6, know your enemy. And so I put here on the slide, who can reach assets transferred to a protective structure? And the answer depends upon the class of assets, how they're owned, which is your structuring essentially, and then who intends to seize them. And why do we say that is because there are a line of creditors that I like to call super creditors, and essentially these are government agencies. In the cases where you see the outlier opinions oftentimes, the injunction to freeze cash assets, as in the US v. Grant, cases where individuals end up in jail for failing to repatriate assets from offshore trusts, such as Anderson and the Lawrence case, which is listed down under the bankruptcy trustee cases. In cases where the single member LLC, those folks who have practiced in this area for a while know that the single member LLC used to be protected from foreclosure up until a line of cases starting with In re Albright in 2003 and culminating in Florida with the Olmstead case in 2010. Now the single member LLC in many jurisdictions is subject to foreclosure, as opposed to a multi-member LLC, which is not. A multi-member LLC still has charging order protection. That all started with the Albright case, and that Albright case was a bankruptcy case. The Olmstead case was a case with the FTC. The FTC is a government organization with almost unlimited resources to pursue a bad actor if that bad actor ends up on the radar. SEC v. Bilzerian, another case where sham trusts led to jail time. All of these cases, you'll see one recurring theme is these are government entities or where a bankruptcy trustee is involved. Whenever you are dealing with the government, you need to be extra cautious with respect to any actions you take to try to move or protect assets. If there's a government claim, you want to proceed with caution, and oftentimes we just tell folks that you're very, very limited on how you can deal with government claims once those claims have already arisen. There are also special laws that I've listed here on the next slide. The Federal Debt Collection Procedures Act extends the statute of limitations, which you'll recall is a defense that I particularly like with respect to fraudulent transfer claims. Most states have a 2 or 4 year statute of limitations on fraudulent transfers, sometimes with limited tolling, particularly for those deemed made with actual intent. There might be a 1 year tolling provision, for instance, in Florida. This statute under the Federal Debt Collection Procedures Act extends the statute of limitations to 6 years for government actors. I've also listed here several other statutes with the citation, ways you can get in trouble criminally and with civil liability for obstructing the government's ability to collect taxes, for instance, or obstructing the government's ability to collect debt. The Bankruptcy Code contains several provisions. There is a cause of action, a criminal cause of action for fraud on the U.S. You could run afoul of certain money laundering statutes, etc. So I want you to be aware of who you're dealing with. If you end up having a claimant, if that claimant is a government claimant, then you should be fully aware of who you're up against. All right, rule number 8, if it sounds too good to be true, maybe it is. And what we're talking about here is that you keep it simple in most circumstances. Complex arrangements, if your client can't explain it, you can't explain it, it's probably going to struggle to pass muster. Some examples here, folks here in Florida think that using a land trust, which is like an anonymous trust where you don't have to disclose who the owner is going to add some protection to the ownership of property. But the reality is, if you own a rental home, for instance, in a land trust, and somebody gets hurt in that property, they're going to be able to sue the trust, and so that asset's going to be exposed anyway. And in any lawsuit that you're going to have discovery, you're going to be able to find out who the owners are. The intent of those anonymous statutes wasn't to provide asset protection. It was just to allow people to own property anonymously. Actually, starting with the Disney organization took advantage of that to acquire large plots of land back in the 1960s and 70s. Moving assets to offshore protected structures, that sometimes works. But again, you have to do it with the right timing and intent, and really understand the jurisdiction you're going to and understand what types of assets you're moving. Cash and accounts that could be held offshore in an offshore entity might work. Real estate sitting in Florida might find very little value in being secured in a offshore LLC, because a court, just like in the Barber case, could disregard the existence of the entity. Purportedly exempt accounts, statutes provide a lot of exemptions. You should take advantage of those. But I also mentioned to you the Delaware statute that would purport to exempt Delaware bank accounts from garnishment and attachment. I've seen those work, but I've also seen it backfire. So don't rely on something like that, which is really just a glitch if you're not in Delaware, for asset protection, because there's several other ways to reach those assets. A creditor, for instance, could go to court and seek an order compelling you to repatriate those assets, and probably has a 50-50 chance or better in actually having that work. Spousal transfers, transferring assets from husband to wife and vice versa. There was a colorful case a few years ago where somebody in Florida tried to do that, and it blew up in his face. He transferred all of his assets to his wife in the face of claims arising out of the Madoff clawbacks. And his wife, a former pinup model, promptly filed divorce right after she got control of all the assets. And things took even uglier turns from there. The lawyers who engaged in those transactions ended up being sued, and it just was it was a bad idea. You have, to your advantage, if you're married in a TBE state, you have TBE titling. I encourage folks to often take advantage of that, but transferring assets to a spouse to avoid claims is rarely a good idea. Funding a trust for your own benefit. Self-settled trusts are recognized in 17 states in the U.S. and in several offshore jurisdictions, but they are limited purpose. You're not going to be able to put all your assets in those, and you can't do those in jurisdictions that don't recognize them. And even in jurisdictions that do recognize domestic asset protection trusts, you often have to strictly follow the requirements of the statute, or you won't be entitled to the protection. There's a Tennessee case and there's an Alaska case. If you're interested in those more, please shoot me a message and I can get you those cases. We often have clients come in with revocable trusts and say, well, I've talked to an attorney, I've got a trust, and they think they're protected, but a revocable trust offers no asset protection benefit. In Florida, we have a statute directly on point. We also have cases on point. And the whole point of a revocable trust is the fact that it's revocable. It can be changed by the settlor or the grantor. And the more control the grantor has, the less protective something's going to be. Always remember that. The client has a balance that they have to find between control and protection. They want to maintain control, but they want protection. And really, to get maximum control, you get more protection, by giving up control, either through a trust or through an LLC that's managed by somebody else. Those two are generally inversely related in the asset protection arena. And again, here a few cases of example: complexity versus clear, direct, timely, and legitimate planning. Do your planning in advance. Use things that are available to you by statute, the exemptions, and the other mechanism. Use trusts to protect personal assets generally. Use LLCs and other business entities to protect business assets generally. and understand that just being exotic is not necessarily protective. Again, on planning need not be complicated. So we went from if it sounds too good to be true, maybe it is, to planning need not be complicated. That's the next rule of asset protection. And again, I've talked about titling. Titling is husband and wife tenants by entireties. Using exempt assets to the maximum benefit allowed. Your traditional spendthrift trust is tried and true for over 500 years. People try to crack them. I've been involved in litigation when people tried to crack them. If you have a legitimate trust that's been set up you're following the statutory requirements, set up with competent counsel, and the person who sets up the trust isn't trying to evade or avoid creditors, even if the beneficiary of the trust, in one circumstance we had a client who's the beneficiary, in a couple circumstances where the beneficiaries ended up in jail because of fraudulent activity and everything else. One person had a website set up talking about bad things this person had done. The assets were still untouchable. You put those into a trust, you include your traditional spendthrift provisions, and that's going to be as protective as anything out there. And don't overlook the benefits of insurance. I like to recommend that clients have maximum insurance for liability, particularly for cars, if you have boats, umbrella insurance. Take advantage of the maximum insurance coverage you can get, because that insurance, if you ever do have an issue, provides great low-hanging fruit to a creditor. And I've been involved in many cases where we've gotten creditors to settle for money from an insurance company when the creditor understood that, or the plaintiff's counsel understood that getting any assets beyond that was going to be a struggle. They'll take the low-hanging fruit when they can get it. It can get you in trouble. And we have, I want to go back on this slide here, this Husky International Electronics v. Ritz. That's a case where the Supreme Court of the United States essentially equated a fraudulent transfer to fraud. And what that tells me is that if a fraudulent transfer is fraud, you can have a conspiracy to commit fraud, you can have an accessory to fraud. Third parties, such as not only the recipients of assets, but the planners, attorneys, financial advisors, bankers, other people who might be involved in the transfers, can get themselves in trouble. And I want the attorneys to stay out of trouble and avoid potential liability by not getting involved in a fraudulent transfer. If you ever have a question about that, here's some warning signs to look out for on this last slide here. And if you ever want to talk through one of these issues, I welcome you to contact me. My contact information is here on the slide. Feel free to reach out to me with any questions. Thank you again to Law Practice CLE for letting us present today, and thank you for being in attendance. Bye-bye.